After you've been arrested and charged with a crime, the district attorney's office has to review the complaint for probable cause. And that means a police officer is drafting a report, finalizing it, and sending it off for review. Assuming there's probable cause to believe you committed the crime you're accused of, then a draft of the complaint will be sent to the court, a docket number will be generated, and in time for your court date for which you have to arrive at arraignment. At the arraignment, the purpose of that event is for you to plead not guilty. That's what I'm hoping you're doing, because if you plead guilty, that's the end of your case. That means you will be sentenced that day. Could be an imposition of a fine. It could be jail time. Jail time could be imposed at a later date. There could be probation. But if you plead guilty, that is the end of the case. And when you plead guilty and later have regret, you really have no recourse because you were explained all of your rights and that you didn't have to plead guilty that day. So my suggestion is, if you're watching that video, that you go and plead not guilty. After you've pled not guilty, you'll get a new court date for what's called a dispositional conference. It's an opportunity for me, for example, or a member of my team to speak with the DA, and oftentimes a judge gets involved for a mediated conference. We talk about how we can resolve the case by agreement. The goal here is for us to achieve an outcome that meets your objectives, whatever that is. Sometimes there's a little bit of give and take from both sides in order to get what everyone wants collectively, which is a good resolution for the case without having to go to trial. If we can't resolve the case and there are issues constitutionally problematic in your case, then we'll file a motion to suppress. Motion to suppress evidence, a violation of your 4th, 5th, or 6th Amendment rights. Then we'll litigate that, meaning we'll have a hearing at some point where we'll cross-examine the officer, other witnesses, possibly present evidence if necessary, and then a judge will rule on it. The judge could rule that the state violated your federal or state constitutional rights in some manner and some level of evidence may be excluded. Or the judge may rule against us and find that the state did not violate those rights and the evidence is going to come in. Finally, the case will be set for docket call. If the case hasn't been resolved by this point, this is the call of the list. This is where we have to come in and say we're ready for trial, and then the court will adjust their calendar and schedule us for jury selection. The final part of this entire process will be jury selection and trial. This is a very stressful time for clients. It's stressful for attorneys. It's our real performance hour. We're doing everything we can to try and obtain a not guilty verdict. But at the end of the day, we're leaving a decision in a group of 12 or 13 people's hands. They have to decide unanimously whether or not you're guilty or not guilty, whether or not the state has met its burden of proof or failed to do so. That's really the standard. But it's a gamble. It's a gamble for both sides. It's why, when it's possible, when we can find an area of agreement that you can live with, it's oftentimes in your best interest to take a plea agreement. But in some instances, the only way to obtain justice for our clients, to get that outcome they really need, is to go to trial and hopefully win. So that's the 10,000-foot overview of the process. So what happens, nitty-gritty, after you've been arrested? You're literally in handcuffs now. They're bringing you down, say, to the Cumberland County Jail or the York County Jail, for example. They're going to process you in, meaning they're going to inventory your items. They're going to sit you down in the jail cell. If you're intoxicated, they may not let you out for 8 hours, and you're going to sit there. You're going to sit there until a bail commissioner appears. The bail commissioner's job is to determine whether or not bail should be set in your case without having to see a judge. So if the bail commissioner gets there, takes a look at your case, asks you some questions, determines that bail should be set, they'll set a cash bail usually. Depending on the nature of the crime, it could be a $10,000 cash bail. It could be a $100 cash bail. Just depends on the nature of the crime. If you're not able to post bail for whatever reason, or the bail commissioner says bail cannot be set based on the nature of this crime, you're sitting in jail and you're not going anywhere. You won't be going anywhere until you see a judge. And the purpose of seeing the judge is to be read to you the charges so you understand what it is that you're facing. In this instance, it's a felony. Then you perhaps are going to have the charges read No plea will be taken because it's an initial appearance. The judge will tell you the maximum penalties involved, and then bail will be set, hopefully at an amount that you can afford. In the event it's a misdemeanor, you will be read the charges. You'll be asked to plead guilty or not guilty. If you plead not guilty, again, bail will hopefully be set. A judge could have you on a no bail hold based on the nature of the allegation and if you were already on bail for another crime at the time you committed the new crime. So a lot goes into the decision making for the judge or the bail commissioner to determine whether or not bail should be set. But this is the granular process of what to expect. If you can't make bail, you're sitting in jail until you see a judge. That is the long and the short of it. I wish I could just give a message to everyone, and I think I will, watching this video. What do I do when the police are interrogating me about a crime I did, or perhaps in this case didn't commit? The best thing you can do is shut the fuck up. End of story. You're not going to make things better by telling them your story of what you did or didn't do. 99% of the cases I see where someone has waived their Miranda rights and decided, I'm going to talk to the police, have generally made things significantly more difficult for their defense team to get them out of this real bad situation they've put themselves into. Don't waive your Miranda rights. Don't answer questions, period. You don't have to. Nothing requires you to answer questions. So don't. Just shut the F up, please. This is probably the number one question I get from clients when I first meet with them. Shouldn't they have to dismiss everything? No one read me my Miranda rights when I was arrested. Well, let's think of every cool cop show we've ever watched, every cool court TV show we've ever watched. What happens when somebody gets cuffed and stuffed, and as they're putting in the back of the cruiser, they're launching them in and they go, you have the right to remain silent. Anything that you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, sir, an attorney will be provided to you at state expense. Boom, door slammed, Miranda rights read, all bases are covered. That's not how it works in the real world. Law enforcement only needs to Mirandize you if you're in custody or you've been formally arrested, and they're going to question you about the events that led to your arrest. Here's an example of where it doesn't apply. Mike, I'm sorry I had to arrest you last night, but did you see the Sox game? Yeah, I'm sorry you had to arrest me too. The Sox game, I lost track of it after the sixth inning because I drank 15 beers and couldn't keep track of anything and then fell out, passed out, got in my car, got drunk, and you're just rambling away. Now you want all this, your statement suppressed because he didn't Mirandize you. Well, guess what? The officer wasn't questioning you about the circumstances that led to your arrest. He just asked you if you saw the Sox game. It goes back to another video about just keeping your mouth shut, not answering questions. So they do not have to Mirandize you unless you've been arrested or you're in custody. And that is a very specific factual analysis that your attorney will do to determine whether or not Miranda should have been read to you. But in the vast majority of cases that I see, at least at the lower misdemeanor level, Miranda is not going to apply. If you've got questions about what to expect when you've been arrested, I'm Attorney William Bly. You need to call the attorneys at the Maine Criminal Defense Group. You got questions? We got answers.